Dear Master 2 Business Law students, welcome. I am your professor, and I will be your instructor for the English course. I look forward to delving into our subject together and guiding you through this exciting journey. Let's make it an ultimate learning experience. The Competition Authority is an independent administrative authority responsible for preventing anti-competitive practices and monitoring the functioning of markets. It aims to ensure respect for the law linked to the defense of a sufficient market competition. Undertaking or entity, also enterprise, is any entity engaged in an economic activity that is an activity consisting in offering goods or services on a given market, regardless of its legal status and the way in which it is financed, is considered an undertaking. To qualify, no intention to earn profits is required, nor are public bodies by definition excluded. The rules governing concentrations speak of undertakings concerned, that is, the direct participants in a merger or in the acquisition of control. A financial fine is a mandatory monetary penalty that is imposed by a court, commission, or other government authority and is paid to a public treasury. The primary purpose of fines is to deter antitrust or competition law violations. The great majority of antitrust and competition law fines are imposed on companies to deter price fixing, bid rigging, and other illegal collusive conduct. Some jurisdictions impose fines for other offenses, such as illegal dominant firm behavior or failure to report mergers and acquisitions. Abuse of dominance is unilateral conduct using dominant market power, or a dominant position, to damage market competition and ultimately welfare. Most jurisdictions address the issue by prohibiting use of dominance or substantial market power, taking different approaches to terminology and the relevant threshold of market power. Dominance itself, or the degree of market power required by other wordings, is generally measured by the ability of an organization to act without significant constraint, or to influence prices to exclude competition, or to profitably maintain prices above the cost of supply in the long run. Conduct which may infringe abuse of dominance and like provisions includes predatory pricing, exclusive dealing, loyalty rebates, tying and bundling, refusal to deal, and in some jurisdictions, excessive pricing. The concept of predatory pricing comes into play when a dominant undertaking deliberately reduces its prices to a loss-making level for a short term to discipline its existing competitors or foreclose the market to new entrants with a view to strengthening or maintaining its market power later on by way of the foreclosing effect of such predation. To that end, in broad terms, predatory pricing could be defined as the setting of prices at an unreasonably low level below a cost parameter, to induce a competitor to exit the market or to deter its entry or expansion. In economics and law, exclusive dealing arises when a supplier entails the buyer by placing limitations on the rights of the buyer to choose what, who, and where they deal. This is against the law in most countries, which include the USA, Australia, and Europe, when it has a significant impact of substantially lessening the competition in an industry. When the sales outlets are owned by the supplier, exclusive dealing is because of vertical integration, where the outlets are independent. Exclusive dealing is illegal in the US due to the Restrictive Trade Practices Act. However, if it is registered and approved, it is allowed. While primarily those agreements imposed by sellers are concerned with the comprehensive literature on exclusive dealing, some exclusive dealing arrangements are imposed by buyers instead of sellers. Exclusive dealing can be considered as a barrier to entry, especially in markets that operate under imperfect competition, which is either monopoly or oligopoly, where there is price and product differentiation as well as an imbalance of market power between incumbent, entrants, and competitors due to the existing of vertical integrations within the market, leading to market inefficiencies. Exclusivity clauses in commercial agreements impose a restraint on a contracting party, limiting that party's freedom to choose the products and/or services it may offer, the customer categories it is permitted to serve, the sales channels to use, or the geographic regions in which it is permitted to operate. Exclusivity agreements are not automatically illegal in South Africa, and where such agreements are proven to have an anti-competitive effect, justifications may be entered proving that technological, efficiency, or other pro-competitive gains arising from that agreement outweigh the anti-competitive effects. Commentary exclusivity clauses can be assessed either under a per se, effects-based, or abuse of dominance framework. Competition regulators around the world take different approaches to the treatment of exclusivity clauses. In some jurisdictions, exclusivity clauses, also referred to as exclusive dealing, with the ultimate objective of excluding other sales channels, e.g. online sales, through input foreclosure, and/or discriminatory practices, are per se unlawful. However, other jurisdictions adopt an effects-based approach by assessing whether the impact of the restriction is detrimental on competition using three main theories of harm, viz. Reducing intra-brand competition, softening inter-brand competition, or foreclosing existing or potential competition. Finally, some jurisdictions also apply the abuse of dominance framework by assessing whether the one contracting party has market power in the upstream market according to the leveraging theory, i.e. whether manufacturers are leveraging their position in the upstream market to give themselves advantages over their rivals in the downstream market, the intent behind the restriction in the downstream markets, and the effects of the conduct. In regional trade blocs like the Common Market for Eastern and Southern Africa or the European Union, a fourth theory of harm may be applicable. Restrictions may partition national markets according to national borders and frustrate the objective of achieving an integrated single market for the benefit of consumers. It is typically the case that the jurisdictions with an effects-based framework also assess exclusivity clauses under an abuse of dominance framework, and the theories of harm may be interchangeable. For example, in South Africa, exclusivity clauses are typically assessed in terms of the vertical restraints provisions, Section 5(1), and under the abuse of dominance provisions, Sections 8 and 9 of the Competition Act, 89 of 1998, as amended. The Competition Act. Section 5(1) of the Competition Act states that an agreement between parties in a vertical relationship is prohibited if it has the effect of substantially preventing or lessening competition in a market, unless a party to the agreement can prove that any technological, efficiency, or other pro-competitive gain resulting from that agreement outweighs that effect. This contemplates what is referred to as a rule of reason or effect-based assessment related to competition effects, rather than a per se consideration. Loyalty rebates. As competition law generally strives for lower prices on the market, it can appear counterintuitive to penalize rebates granted by companies with market power. However, on closer inspection, the rationale that underpins the view that rebates can sometimes be anti-competitive emerges, where a rebate is only granted based on conditions that induce loyalty or near exclusivity on the buyer's side. This can foreclose the seller's competitors from access to the market, possibly even leading to the competitor's market exit that ultimately benefits the seller. Point 1. While loyalty discounts can help to align the supplier and the purchaser's interests, they can also prevent entry or expansion, lead to market exits, or involve below-cost pricing. The question, then, turns on how to distinguish between pro-competitive rebates that competitors can compete on and anti-competitive rebates that may constitute vehicles to foreclose a market to competitors. Unfair competition is conduct by a market participant which gains or seeks to gain an advantage over its rivals through misleading, deceptive, dishonest, fraudulent, coercive, or unconscionable conduct in trade or commerce. Abuse of economic dependence, also known as an abuse of a superior bargaining position, ESBP, is a legal concept that addresses a situation where one party to a transaction that is in a position of relative strength to another abuses such position. In contrast to abusive conduct by dominant undertakings prohibited by law, abuse of economic dependence does not require a dominant position in any market. Instead, it requires some sort of superior position relative to the counterparty of a transaction and aims to protect the weaker party from the abuse of such position by the party in the superior position. Collusion is an anti-competitive business practice that firms perform in a coordinated manner to obtain benefits at the expense of consumer welfare. A distinction exists between explicit collusion, concerted practice, and tacit collusion. Explicit collusion between competitors, which includes communication and agreement with respect to core elements of competition, is illegal worldwide. Other practices that involve less explicit arrangements, such as information exchange, are known as concerted practices. These are also illegal if they might restrain competition. Tacit collusion, a practice where a competitor unilaterally follows the behavior of other competitors, is not illegal in and of itself. Or coordination between undertakings which, without having reached the stage of concluding a formal agreement, have knowingly substituted practical cooperation for the risks of competition. A concerted practice can be constituted by direct or indirect contact between firms whose intention or effect is either to influence the conduct of the market or to disclose intended future behavior to competitors.